Hello and welcome to our presentation on regional trade agreement, and this is between World Trade Organization and Andean Community and CUSMA. Thank you for listening and enjoy this presentation that is presented by Julia and me, Jacob.
In 1995, the World Trade Organization, or WTO, was founded as the successor of the General Agreement on Tariffs and Trade, or GATT, which was founded in 1947. It was formed to address weaknesses GATT had, such as a lack of formal dispute settlement mechanisms and the increasing complexity of global trade. The goal of the WTO is to promote free trade, set and enforce international trade rules, ensure fair competition, help developing nations benefit from free trade, and resolve any trade disputes between member countries regarding agreements about goods, services, and intellectual property. The Dispute Settlement Understanding, or DSU, acts as a foundation for resolving trade disputes through consultations, panel reviews and reports, and appeals to the WTO's appellate body. The goal of the DSU is to resolve disputes to ensure the stability of global trade.
So next we're going to talk about a little bit the history of the Andean community. So first, it was founded in 1969. Different countries are Bolivia, Colombia, Ecuador, and Peru. It has a system called the Andean Tribunal of Justice, the ATJ, and it was formed in 1984. And it has very similar laws as the Andean Community laws. And ATJ oversees any dispute, and it maintains order by the preliminary rulings, infringement procedures, cancellation actions, and in total, it creates legal consistency and a deeper regional integration between countries. So for the procedure of the Andean Community, for the dispute procedures, it starts with the preliminary rulings. So the court members must consult ATJ before involving Andean laws, and as well as that, it keeps all the laws very similar in all the countries. With infringement procedures, the General Secretariat of another or any other member of state can file a complaint if the country violates an Andean law. ATJ examines the case, either binds it or to have the country comply. If there's no compliance, then it can lead to sanctions or further legal steps. So for annulment or failure to act, if an Andean group was supposed to act but didn't, ATJ is allowed to interfere and tell them what they need to do. So for CUSMA, the history of CUSMA, in 1994, NAFTA was created, and it was established between the countries Canada, USA, and Mexico. And then in 2020, it was moved from NAFTA to CUSMA, and that's what we have now. And it was created to improve disputes and complaints and to have a lot more cleaner process. So about the different procedures of CUSMA, it has three different dispute mechanisms. First one is state-to-state settlement. It is used when one country believes another is violating an agreement. So the procedure is the first consultation, which has to be within 30 days of the complaint. And then it has a formation of panel, and then it has a panel report, and then any recommendations that the party has to do. And again, if the losing party doesn't comply to the decisions, the complaining party, the losing one, can lose trade benefits and have tariffs. So then this is usually applied when it has any market access, investments, and any technical barriers to the trade. So the second one is a rapid response mechanism for potential labor violations. So this is what they mainly specify in and they're known for. So during the procedures, they have a request for of review of a faculty, and then it has verification, and then it has a panel formation, and it chooses a possible sanction, such as blocking the imports from that facility. And then this aims to improve enforcement and labor rights quickly and directly. So thirdly, a binational panel review mechanism is addressing anti-dumping and countervailing duty measures. So the procedure is a party challenges a national agency trade remedied decision, and then a binational panel of experts review the case instead of a domestic court. And then finally, the panel can be upholded or reversed to the original decision that they had. So this just protects the industries from any unfair decisions. So yeah, CUSMA ensures the panel formations can no longer be blocked as it used to be did in NAFTA. So that's a really good improvement that CUSMA has.
Now let's begin with the WTO. The WTO's dispute settlement process has 5 stages. The first is consultations. This stage allows the different parties to meet and hopefully resolve the issue satisfactorily for both parties. The second stage is the establishment of a panel. Panels provide impartial and expert examinations of trade disputes. The Dispute Settlement Body, or DSB, begins the panel formation process when it receives a request for a panel to be established. They are only established if the consultations fail. Panels are made up of 3 well-qualified WTO members with expertise in trade laws and policies. The role of the panel is to investigate and report on the dispute. Now, there are a set criteria used to ensure the panel members are neutral and able to investigate the dispute objectively. This is why the DSB is essential for managing and overseeing the dispute settlement process. Now, the third stage is the panel report and appellate body review. After the panel hearings and investigations are finished, the panel creates a report. Afterwards, either party can appeal to the WTO's appellate body about the report findings. The appellate body is made up of 7 WTO members, and it reviews the legal aspects of the panel report, and it may modify or force the panel's legal findings and conclusions. Now, the fourth stage is the adoption of the rulings. The panel report or decision made by the appellate body is adopted unless every WTO member agrees not to adopt it. Finally, the implementation stage. Now, decisions are binding, and the losing party is expected to comply with the findings. But if the losing party does not comply, the winning party may be authorized to receive compensations or apply retaliatory measures, like raising the tariff rates against the losing party. Now let's move on to the Andean Community. For the Andean Community, the ATJ has judicial authority and is accessible by member states, institutions, private companies, and individuals. The General Secretariat, or member states, decide if a country has broken any of the Andean rules. To guarantee uniform application of Andean rules, national judges consult with the ATJ to ensure interpretation and validity of Andean rules is applied uniformly. When entities fail to comply with the rulings, the ATJ has the power to annul any acts that are in violation of the legal norms or rules. Therefore, the ATJ is instrumental in ensuring the rules are applied coherently and in an integrated manner. The decisions of the ATJ are binding, and it does not require any legislation for member states to invoke the ATJ in national courts. And of course, to ensure impartiality, the ATJ operates autonomously from political parties. Finally, let's talk about CUSMA. First, consultations are used to try to resolve the issue between the disputing parties. But if consultations fail to resolve the dispute, the situation is handled by a neutral dispute panel with or without the cooperation of all concerned parties. The panel is formed of individuals with expertise in trade relations, and each country appoints 2 panelists after consulting with the other governments to ensure neutrality. The panel is formed within 30 days of failure to resolve a dispute by negotiations. All parties are expected to comply with the ruling of the panel and its final report. Failure to comply may result in suspension of CUSMA benefits and the imposition of countermeasures such as tariffs. The same process applies to environmental disputes. Labor violations are quickly examined by a panel of 3 experts that are deployed to the facility in question. It does on-site inspections to accelerate the process. Guilty parties can be punished by other member nations blocking their exports and services. CUSMA also has the Investor State Dispute Settlement, or ISDS, but it's mostly restricted to disputes between Mexico and the US and can only be used after they have exhausted all domestic remedies. This is to protect the member country's government's right to regulate such matters.
So next is we'll talk about the strengths of WTO and how it relates to the Andean community in CUSMA. And you'll see how the Andean community is very similar to the WTO and possibly even better. So you'll hear about that at the end. So WTO it is very structured. It has a consultation panel, perils, and then finally an enforcement. Andean is very similar as the ATJ follows those rules. And with CUSMA, it is partly as structured as it has consultation panel and ruling. As NAFTA used to have blocking, CUSMA is now better at that. And then next we have judicial and quasi-automatic, where for WTO, rulings are based on legal arguments and not on negotiation. ATJ follows the court system that overrides all the nation's laws. And then in CUSMA, the rules are much clearer than it was with NAFTA, and there's also a safeguard for the panel, which is good. So the automatic adoption of rulings. So rules are adopted unless there's a consent to block them for WTO. For ATJ, or Andean Community, rulings are directly applicable without any political approval. So with CUSMA, it is not so, because there's no automatic adoption, as there have been enforcement from not CUSMA, but by political and economic pressure, which isn't good. So with the compulsory and enforcement, WTO, once a ruling is adopted, the losing party faces sanctions such as tariffs. So in the same way, in the Andean, the rulings are compulsory, and ATJ can override the domestic law and enforce Andean laws. So with CUSMA, it's partly like that. Rules are binded, but enforcing the CUSMA rules is kind of weak. The party can get out of the panel before it is formed, and CUSMA can have deadlines. I mean, they're trying to reduce that way of parties blocking it, but they could stall it a little bit, especially with political aspects to it. And then finally, with consultations and mediation, this is the most important part for WTO, and as is trying to have a voluntary resolution, and it's same as Andean. It has a very strong consultative culture, and people are encouraged to resolve disagreements through dialogue. And the General Secretariat is a central administrative body of the resolving conflict, which is good to have. And same as CUSMA, it requires consultations as its very first step, and usually this is where cases are settled. But again, it also has some timelines that they need to follow for a certain time. So next we'll talk about challenges that WTO has. So the first one is speed resolution. WTO is often kind of slow, and it can take cases up to like a full year to get completed. With Andean, it can be very fast. It can be done in less than a few months. With CUSMA, it can be done pretty quickly, especially if it follows the labor laws or the environmental laws as they specialize in. But all the other different topics that they cover, it may take them longer. So we don't really know if they're always fast, always slow. Kind of in the middle. So complexity, WTO is known to be kind of complex, And as it involves a lot of different things like technical, trade law, cross-border subsidies, dumping, SPS, measuring, and much more. And it requires a high legal capacity. With Andean, it's a bit better. It focuses mostly on regional integration issues such as tariffs, misapplication, customs, and more. And so it is a bit more accessible than WTO. With CUSMA, it mostly covers, like I said, like the labor environmental standards, which is kind of a new thing. Not many other people have that, so they don't have many cases to verify their theories when they talk about this. So some people suggest that it's a bit difficult to argue and interpret the conflict. So that's pretty interesting. So in conclusion, I like to add that after all this research, I would say that Andean Community is very similar to WTO, but even better, especially when you see these challenges that they have. WTO can be very complex and it can be pretty slow, but with Andean, it can be much faster. Things can be done in just a few months, and it's not as complex. And it also has a lot more enforcement over the nation's laws, other than CUSMA, which their enforcement's kind of low, which is not so good. So, yeah, thank you so much for listening, and have a great day.